Yeah, I think we should just go ahead and get started.
Thank you. This meeting is called to order. Good morning and welcome to the October 11th meeting of the Douglas County Criminal Justice Coordinating Council. My name is Pam Weegan and I'm the chair of the CJCC. I want to pass on a little information regarding how we'll conduct our meeting on Zoom today. We ask that all members please turn on video if you have it. We ask that all members and presenters mute their line when not speaking. We ask that you please identify yourself each time you speak. And if you have a public comment to make during the public comment section of the agenda, please use the raise your hand function on Zoom. Recordings of the CJCC meetings are available on the CJCC website after each meeting. Our first agenda item today will be a presentation about independent assessment conferences, formerly known as mediation, with District Attorney Suzanne Valdez. Suzanne.
Good morning, everyone. Thank you for allowing me to share with you just another tool we have in our toolbox here in the DA's office. I'm not sure who can share their screen with me, but I do have a PowerPoint to kind of guide us through my discussion here. So Zaina?
Yeah, you should.
Can I go ahead and?
Yeah, you should be able to share your screen. If not.
Here we go. Let me see here.
Awesome.
Can you see it?
Yes.
Okay, great. So about a year ago, we began exploring the idea of having an independent sort of third-party neutral individual to assess our cases and try to give us kind of an alternative, if you will, to having cases go through the court system. And criminal mediation has been around, I'm not really sure kind of how it evolved to criminal mediation, but when you think about mediation and in terms of an alternative to the court system, it's been around for a while in terms of at least civil litigation. So it really is an opportunity for parties to come together, have a third-party neutral individual who can assess a case, help get the parties to understand the strengths and weaknesses of their cases, and then if they're positional, to get them to sort of a meeting of the minds and hoping to resolve the case. So it's been around, at least in the civil context, for many years. Recently, and again, I can't really put a timeline on it, it evolved into the criminal sphere. One of the areas that was very concerning, at least from a victim's perspective, is that the criminal justice system is, you know, it's the state, it's the defendant, and how do we sort of put the victim or anyone who's been traumatized by the crime into the mix? So it's evolved over time. It's actually a very powerful tool, and so I want to talk a little bit about how we use it here in Douglas County. So starting again, you know, sort of keeping in mind with our mission, which is a safe and just community. We wanted to look at alternatives to incarceration. We wanted to look to alternatives to the criminal justice system so that we could get finality, we can move cases through quicker. And this is just a tool that we decided to use. So it's called criminal mediation because it's used using the same sort of tools and skill set, if you will, that mediation in the civil litigation context has used for many, many years. In fact, the Kansas Supreme Court allows for mediators, trained mediators. You can be a lawyer. You don't have to be a lawyer, although depending on the stakes of a case, having a legal training or a legal background certainly is really helpful. But certainly the mediation rules allow for this third-party neutral, if you will, to look at the case very holistically and help resolve the case. So I thought I would do a presentation because I think there's some sort of misperception of what it is, what it isn't. And so that's what I'm going to talk about today. So it is a form of mediation, and really the moniker criminal mediation, the moniker itself is just sort of deceiving. What it really is, in essence, is an independent assessment conference. And I'm going to explain to you kind of everything that goes into this. The idea is that, again, we are looking outside the traditional criminal justice procedure where we have charging, arraignment, preliminary hearing, potential plea, where there may just be sort of, bare bones plea negotiations without thinking about much outside of what a deal can be, brokering a deal, if you will, and trial, to how do we go about facilitating a plea agreement in a more holistic way. So it is a formalized criminal mediation process. It uses a lot of the skill set and knowledge, if you will, that mediation uses when we think about alternatives, an alternative dispute resolution. It is a tool, and this is what's really important, to resolve difficult and very serious cases short of trial. But it is not in itself a sort of let's come together, let's have a group hug and the case goes away. So I think that's probably the public misconception, is that somehow when a case goes to criminal mediation or the independent assessment conference, that we're all just going to sit around a table, like I said, sing kumbaya, and then the case is going to be dismissed. That's not what happens. What this really does is it's a tool that we use to try to get the parties to come together and resolve cases short of trial. These are very serious cases. These are very difficult cases. And oftentimes are cases where the defendant faces serious amount of time in prison. The reason it's become so important for our county to use the independent assessment conference is because we have a very robust pretrial release program. And that's in place to keep our jail population down. So those folks who are in our jail are those who have are public safety concerns. They may have a very robust, if you will, or serious criminal history where public safety is a concern. If it looks like folks who are charged with a serious crime, but this may be their first offense, they don't have any prior criminal history where they present really a public safety concern, we work with pretrial services to have that individual put on house arrest or monitored in a different way prior to trial. Well, what happens is when people are out of jail or they don't make bond, or excuse me, have made bond and are out in the community, when they do face serious charges like rape, vehicular homicide, those kinds of very serious cases where they're presumptive prison, it's very difficult for the defendant to get their minds around the fact that they may have to do serious time in prison. So this helps with that process and getting the defendant to understand, hey, listen, you're charged with a very serious crime. I'll give a very good example. Rape, for example, is you have those individuals who don't have a prior history of rape. It's still a level 1 charge, very serious, but they're on house arrest. There's some sort of monitoring that's going on and they haven't been in jail. They've made bond or whatever. So this idea of doing prison time is just completely a foreign concept to individuals. So it really helps with this third-party neutral who happens to be Judge Moriarty, a very well-trained individual who has about 45 years of criminal practice, both as a defense prosecutor and judge, to get the defendant to understand that. So it's really helpful in that regard. Most importantly, I think also importantly, I should say, is it allows for the inclusion of views and perspectives, not only by direct victims, but indirect victims, family members, law enforcement, if they have a say in the case and they want to be heard, and anyone else who the mediator may decide to bring into the fold. And I'll give you some examples at the end of the presentation. It's strictly voluntary. There are some jurisdictions where it's required. We don't require folks to engage in mediation. The defense can propose it, the state can propose it. Again, these are gnarly sorts of difficult cases where we may be very sort of polar opposites in how we think the case should be resolved, but this gets us all together to figure it out and maybe come to a meeting of the minds. And probably what's really good for the defendant and for the victim, especially if they are talking freely about their trauma, if the defendant is trying to kind of explain why maybe the act occurred, it is confidential. In other words, the information that is shared in this conference is not admissible in court. So why use the independent assessment conference? Well, in our case, it involves an independent and neutral trauma-informed facilitator. Being trauma-informed, I know we use that phrase a lot, but it really is it's good to have that knowledge, that background, and that understanding that when a criminal act, typically a violent act, occurs to an individual involves the community, lots of people are affected by the actions of the defendant. And just to give you a sense of what I'm talking about, you could have an individual who has committed, for example, an armed robbery. The defendant is, of course, the person who committed the act. The person who's on the other side of the gun, of the barrel of the gun, is traumatized, but it could be that the family is affected by, for example, that individual may not be able to go to work if it's a holdup at a gas station. So they're affected by that. They see a change in their family members' demeanor because they're traumatized. Similarly, the defendants, maybe parents, are upset that, how could this happen to, for example, my son, this is very upsetting to me. All of those individuals can be heard if they want to, and the judge, the facilitator determines that they should be heard. And oftentimes he's very open to hearing how the act, the criminal, again, the alleged criminal act may have affected the direct victim, but those who are surrounded by it as well. It really promotes a holistic approach to assessing the case, like I've already indicated. I mean, we're able to bring in all kinds of individuals to the table. They can be heard. And particularly, it involves active engagement of victims to be heard in a way that is sensitive, it's confidential, and without the strict sort of public direct examination, cross-examination of what we think about in the courtroom, right? So anytime we prepare a victim for a case, we say, we get to know them, we understand what their testimony is going to be, but the only way they can give their narrative and their story or their experience is through the prompting of the attorney asking the question. So what this allows to happen is that the victim can just sit with the facilitator. And I've seen this happen where the facilitator will say, well, just tell me what happened, right? Tell me how this affected you. Tell me what you want to see happen in this case. And this is a conversation that goes on, and it's very free flowing in a way that I think makes the victim feel better about the process. Similarly, it promotes and allows for offender accountability in a confidential setting. I've already indicated that it is confidential. The facilitator can say, listen, all the facts really indicate that you did this. Can you explain why you did this? What were you thinking? What led up to this? Those kinds of things, which can really help the state and even the victim understand what led to what led to the criminal conduct. So it really is helpful in that regard. And I've already pointed out that it can be asked, the defense can request the independent assessment conference. Sometimes the defendant's attorney says, you know what, my client really needs to plead this out. It's clear that the evidence is clear and convincing, actually beyond a reasonable doubt. But maybe they need to hear from this independent person to let them know that they should take the plea offer that the state has offered. So it can be helpful in that regard, I think, for defense counsel, and certainly the state is always willing to engage in it when the defense wants it. And certainly we ask for it as well. And then I've talked a little bit about protecting vulnerable victims from ever having to testify in court, but yet getting their story and their experience out there for people to understand how this alleged criminal act has been harmful to them. All right, when does the independent assessment conference occur? So when in the criminal procedure of what we're working within here is this triggered? It's typically triggered after the defendant has been charged with a felony crime. Again, we're not using the independent assessment conference for misdemeanor cases. We can, it's available, but typically these are very gnarly, gritty cases where, quite frankly, the state's evidence is strong, but, there's some holes in the state's evidence, or, there may be some weaknesses. And again, we just may be positional in terms of how we want to resolve the case. Typically, when it's assigned to a judge, the judge, if either the state for a status hearing, to decide, is it going to go to preliminary hearing? We call it a no-go status. Is it going to, what are we thinking? Where is this case going to go? That's when we trigger, typically early on, if we can, trigger the IAC conference. Essentially what that does is it takes it off the court's docket. If the parties agree to go to have the conference done, it stays the prosecution process. Again, it's voluntary. So if we request it and the defense doesn't want it, then it doesn't happen. Similarly, if the defense requests it and the state doesn't want it, it doesn't happen. I can say, though, that in the past year since we've been doing it, anytime there's been a request made by either party, it typically is put on the IAC calendar. The conferences are held once a month in person here in the DA's office. We facilitate it because we have a victim witness coordinator who assures that anyone who the facilitator, who is retired Judge Moriarty, wants to see and visit with, that those people are brought in, or there's a Zoom capability. So all of that is managed by our victim witness coordinators. Sometimes the case, depending on its complexity, can take an hour or so. Sometimes it takes 2 hours. Sometimes the judge will meet on a case and decide, you know what, I got to do some follow-up, and I'd like for these individuals to have an opportunity to be heard. So there's all different kinds of models for it. It's really driven by the type of the case, the facilitator, who he wants to talk to, etc. So again, it really is flexible. Importantly, once the IAC facilitator, so again, right now we have the county has a contract with Judge Moriarty, retired Judge Moriarty. After he's done he's talked to everyone who wants to be heard and he feels has some sort of relevant information to how he's going to make a recommendation. He types up a recommendation, he sends it to the state, sends it to the defense, and he says, this is my recommendation for a plea. He lays out what the plea should be, and he also makes a recommendation as to sentencing. Sentencing is done by the judge by statute, so we can make a recommendation, the defense can make a recommendation, but the judge ultimately decides the defendant's sentence, again, within our sentencing guidelines. So he'll make a recommendation. Now, do we have to follow that recommendation? The answer is no. The state could take the position that the recommendation just is not, doesn't meet with something that we feel is fair and just. Similarly, the defendant may say, you know what, that's just too tough, and I think I want to roll the dice and have a trial. So this doesn't require, we're not tied into the recommendation. It is a recommendation. In most instances, a plea agreement through this process is reached, and it goes back to the judge where the case was assigned with a plea date and a sentencing recommendation. And again, we're back in the system and we have finality. If a resolution does not come about, then the case is put on a trial court's calendar. Folks have asked me whether we've started to track data in terms of, like, you know, how resolution and jury trial data and all of that. And we will do that. We just don't have enough information at this point to kind of share with you all of what we're doing. I think probably give us another year and we can get some good data put together on the effectiveness of this particular tool. All right. Lastly, here wrapping up is just some examples, just to kind of give you a sense of kind of putting it all together. In a first-degree murder case, we had the family of the defendant was involved in the mediation. The facilitator, Judge Moriarty, felt like after talking to the defendant had very, I guess, what's the word, a lot of trauma as a child, just dysfunctionality within the family that may have led to some of this, to this conduct and the criminal history of this person. And after talking with the defendant, the Judge Moriarty said, you know, I really need to talk to the grandmother who raised this child, or this defendant. I need to talk to the aunt. And I'm just giving some example of it. But the idea was that the family could kind of explain this defendant as a person, as a human being, that ultimately led to the criminal conduct. So we've involved the family in that regard. We've also involved law enforcement. We've had a case where law enforcement put a lot of time and effort into their investigation. They wanted to be heard on some of the nuances of the investigation. There were 2 officers that were that were patrol officers. We notified them. We said, hey, listen, this is going to criminal, to the IAC conference. We try to notify everyone who's involved in the case. And they said, can we be heard? And we said, absolutely. So Judge Moriarty met with law enforcement to understand the investigation and what led to how the case was charged. And that was really helpful. And law enforcement felt like they had been heard. In particular, with rape cases, we use it quite a bit. These are very serious charges or level 1 charges. And if you have a criminal history of an I, which basically means no criminal history at all, and you're convicted of rape, you can serve a lot of time in the Department of Corrections. We have variations of rape. It's a violent offense. We have some where it is a he said, she said. There was no consent. We have, those kinds of cases that on one end of the spectrum to a very violent act where we see, again, clear evidence of violence in that regard. So with these cases, the judge tries to understand the circumstances, may talk to witnesses who were there, just may try to get a very good sense of the facts so that he can make a recommendation about what he think is a just plea agreement in those cases. And then lastly, as an example, the Jessica's Law cases, getting the defendant on the grid. What does that mean? Our office through our SVU has been prosecuting a lot of the Jessica's Law cases. These are ag and decent liberties against children. In other words, children who have been sexually violated by an adult. These cases are off grid, meaning that if you get convicted of a Jessica's Law conviction, you will go to prison for a very long time, a hard 25, and essentially it's a life sentence. So with these Jessica's Law cases, they're very difficult, they're gritty. You've got young victims, survivors, you've got family members who may be involved. He works with all of those individuals and the defendant with the effort to try to get the defendant on the grid, in other words, serving a very long sentence, but giving that particular individual a sense of hope that they may be able to get out of prison at some point without dying in KDOC custody. So these are very good examples of the seriousness of cases that we have. They're high stakes. Again, they involve, a lot of different individuals, not only the direct victim, the defendant, but people who have just been harmed by the alleged conduct. And so this particular conference or mediation, if you will, is very helpful. It allows us to see the strengths and weaknesses of our case. We hear things that we didn't know about because we just don't have the ability as a state to get information from the defendant. It puts things in perspective for us. Certainly it puts things in perspective for the defendant, and it helps us hopefully to come up with a resolution that brings about finality to everyone, closes the case, if you will. Then the case is ultimately goes to plea and the case is resolved. So that's the independent assessment conference. I think more described in a better way. People still call it mediation. Whatever, it's a tool. We use it. We very much have benefited from it. And I'm glad to answer any questions or wait till the end, whatever the process is.
Thank you, Suzanne. Do we have questions from the council? Susan?
I would just like to ask a couple questions that I get from people in the community. Most of it does revolve around sex offenses. The number one question that I get is there any research out there on the long-term effect of rape victims who go through this process? And is this damaging in the end because they don't get that moment in court?
Sure. Actually, again, there is more anecdotal evidence than anything that it's actually helpful to the victim because they actually get a say in a process that is confidential, free-flowing. And ultimately, when the judge makes the recommendation to us, it is with consultation with the victim, or survivor. So typically what will happen is the judge will explain the law, what the defendant is facing based on, sort of the criminal history of the defendant, the charge, et cetera, and say, hey, listen, this is kind of how I think this should be resolved. So we actually find that it is quite the opposite. Now, if a victim says, I don't want to participate, they don't have to participate. And if a victim says, I want this case to be tried in open court, that is certainly a consideration for us as the state. In other words, it could be that we do participate in the independent assessment conference without the victim because the victim doesn't want to participate. And then ultimately we, as a consideration of the victim's wishes, we may try it anyway, but it's helpful to be involved in this process because it gives us a sense of the strengths and weaknesses of our case anyway, so that as we prepare to go forward, we have all that information. I will tell you that the judge has made some recommendations that we find are just not acceptable, either because the recommendation for the plea is not what we think is within our policies. We don't think it's a just recommendation, and we've tried the case. And we've done that. We've always kept the victim apprised and kept them in the loop on that. So I think it's just another tool.
Another question is, I'm just going to combine these two. Is it traumatizing to the victim to sit in the room with the defendant, and are they allowed a rape counselor to sit in with them?
That's another very good question, because I don't think I was clear on that. Judge Moriarty does not put the victim and the defendant in the same room. So all of this is done separate. There is no meeting of the two together. I mean, that's not what happens. He meets separately with each individual, depending, certainly in violent crime, like we were just talking about, he's never had the victim and the defendant in the same room. So he meets with those separately. Sometimes what he'll do with family members who are, say, of the victim or survivor, he'll meet with the victim survivor separately, then meet with the victim or the family, and then he may bring them together if he thinks that's appropriate. But he uses kind of his skill set to decide who's going to be in the room. And yes, whether it's a DV, the Willow has shown up. I believe I know that the care center has sent advocates to sit with the victim and survivor during a mediation session with a survivor in a rape case. And that was done, and he's absolutely fine with that. We actually encourage that if that's what is required.
And then the last question is the one that I get the most, and that is, why is mediation offered in a case that involves a sex offense against a child?
And maybe, Suzanne, before you answer, can you stop sharing so we can see everybody's faces? I was trying to jump in and get that in there. Sorry, go ahead.
Yeah. Let me figure out how to do this. Okay. Whoops, are you there? Okay, hold on a second.
I think you just go to the bottom and say, stop share.
Yeah, but let me see. I'm on a, sorry.
And I'm sorry to interrupt you, Susan.
No, that's okay. It's all right. I'm just trying to get out of this here. Oh, here we go. Stop share. Here we go. Okay,
Thank you.
there we go. All right, what was your question?
It's the question that I get the most, which is, why would mediation be offered in a case that involves a sex offense that involves a child?
Sure. Again, for the reasons that the victim or the child certainly will probably not even be involved. The family might want to be involved and be heard about just sort of understanding, kind of the get a sense of the case, get the facilitator. Judge Moriarty will explain the case, explain what the charges are. I mean, all this too, we're doing with our office, with our victim witness coordinators and the attorneys assigned to the case. But what it does is, again, it's not it's voluntary, so they don't have to participate. But this just may give us a sense of the judge may look at the file, may look at he looks at the affidavit, the incident report, And it helps him to understand and to give us some advice about, this is clearly egregious, you should probably add more charges, or this is overcharged, or anything like that that will help us resolve the case. Again, those that don't want to participate don't have to. Typically too, in these kinds of cases where there's serious, especially in a sex assault case involving a child, the defendant is charged with a very serious crime and will be serving serious time in KDOC. It is actually helpful for the defendant to hear that from the facilitator, right? That these are serious charges. What has occurred here is very, very, will result in serious time in prison. And let me tell you why. This is the state's evidence. And that would then hopefully result in a plea. And then that prevents and helps the victim or survivor from having to testify, especially when you're dealing with young children. It brings finality, and it gets that individual, accountable, holds that person accountable. So again, it's just a tool. You don't have to participate. No one has to participate. It just really does give us, though, a better sense of the case outside of what we have in our sort of normal procedural toolbox that is allowed by statute. And keep in mind too that the state has to turn over, we have discovery obligations. We have to turn over everything that we have. The defense doesn't have anything to turn over to us. They're not required. I mean, there could be a reciprocal order of discovery, but for the most part, we're just meeting the confines of what the law requires. And oftentimes these experiences have more information, and there's more information relevant to the alleged criminal conduct that can be helpful in understanding why we need to or should try to come up with a plea agreement short of trial.
This is Pam. I have a couple of questions. You said that the county entered into a contract for the services. When was that contract started?
And maybe Sarah can help me with this. I think did it start last November, Sarah, with retired Judge Moriarty? Maybe, I think it was, I can't remember. Time is sort of.
All runs together.
Yeah, I don't have an exact date.
And just out of curiosity, do you know how many cases you've heard so far through this process?
Yeah, well, so we do a day where he comes in, and like I said, some cases can take an hour. If it's, for example, something that's fairly, I don't want to say simple, most of these cases are not. Sometimes he can look at the affidavit and the incident report, talk to the victim, talk to the defendant, talk to the state, wrap it all up in an hour, and then give a recommendation. Sometimes they're very, very complicated cases, and he can spend maybe 2 hours, 3 hours if there's multiple victims. For example, that'll take time. We've had those kinds of cases come up when you get, for example, law enforcement that wants to be heard, that'll take some time. So it runs the gamut, and we are keeping track of everything that we are using, all the cases that have gone to mediation. And I'm happy to report once we get sort of a good sample of that, but they are, again, the gnarly, more serious, complicated cases. And again, I just want to assure everyone, this isn't like we're being soft on on the event or the incident itself. It's just really looking at it and understanding it and getting everyone to participate and having a voice in the resolution, if they want to.
Do we have any more questions for Suzanne? Well, today's kind of the Suzanne show. Our next agenda item is a discussion about reinstatement of traffic fines and fees with Suzanne Valdez.
Yeah, so thanks again. So shifting gears to traffic and reinstatement of fines and fees. I invited our ADA traffic attorney, Dee Dee Knapp, who runs our traffic division with our interns. And then I think I see Deputy DA Josh Seiden as well has joined us. So we had been concerned at the speeding, if you will, in particular, was a curiosity that we had been sort of seeing a phenomenon, if you will. And this wasn't just in Lawrence, but this has been across the country. People speeding and harming pedestrians, harming kids in the school area, school grounds, if you will. In Douglas County, most of us, if you're kind of watching what's happening in the criminal justice system, a lot of fleeing and elude, which again is very, very serious. Car chases, if you will, involving law enforcement. So I'm not talking about the fleeing and elude types of cases. I'm talking just about speeding in neighborhoods, speeding in school zones, and in our community. So with COVID back, in 2020, most prosecution offices, including this office, kind of put a moratorium, if you will, on collection of fines and fees related to traffic offenses. This was mostly done, as I did some research, because people were working from home. You didn't have a lot, kids were not in school. There was basically a shutdown. And so now that we're sort of post-pandemic, we're seeing across the country, of course, people are back on the road, people are speeding, people are committing traffic violations that are harming public safety. We know from our experience that we've seen a lot of it here in district court, although I'm sure municipal court probably sees more of it than we do. But, bicyclists, pedestrians being hurt by those who speed. So we decided that we needed to have a deterrent to the research. There's actually lots of research on this phenomenon sort of post-COVID. And we did some research and have determined that we need to, as a deterrent, go ahead and we need to reinstate our fines and fees for and our traffic diversions for these kinds of traffic offenses. And the questions I get is, what about crimes of poverty, like no insurance, failure to pay your registration, those kinds of things? We have essentially separated these traffic offenses into two buckets. Those were poverty, or crimes of poverty. Speeding is not a crime of poverty. Anyone can be speeding if you're driving a car. So that's not a crime of poverty, but having no insurance may be a crime of poverty. So these are just reinstatement of fines and fees, and really having a deterrent effect on those behaviors within our county, and implementing those policies. So I'm going to have Dee Dee Knapp, who is actually in the weeds on this, kind of jump in and explain a little bit more about kind of our rationale and where we're going with this. It's still a fluid situation, but we wanted to make sure that everyone knew why we were doing it. It really is to deter the speeding and any of this other conduct that causes a public safety to those individuals who are out and about in our community. So Dee Dee, did you want to add anything to that?
Sure. So on the crimes of poverty, as Suzanne mentioned, the tags and the no insurance, our goal on those is not to punish the people who just couldn't afford to get their tags or get insurance, but to encourage them to come into compliance. And if they can show us that verification within a reasonable time that they've done those things, that's our goal. And then we can dismiss the case. Depending on the particular circumstances, we can ask them to pay the court costs if needed. But our main goal is to begin again to enforce the laws in regards to safety, as Suzanne mentioned. And I think we're in the process of revising our policies on how to enforce those specifically. Once we get kind of an outline on it, we hope to meet with law enforcement to get their feedback as well. And then ultimately we'll try to publicize this so that the community understands that we're no longer just dismissing speeding tickets. I think speeding, disobeying traffic control devices, illegal lane changes, those are the things that we're going to focus on for the safety issues.
Thank you, Suzanne and Dee Dee. Do we have questions from the council? Seeing none, we'll move to the next item. We have an update on criminal justice from our criminal justice coordinator. Katie?
Thank you, Pam. My update should be brief. I am working with IT to finalize a survey mechanism for CJCC members to help gather feedback about the potential direction for moving the CJCC forward in 2023. So I just got an update on some of the software that we'll be using yesterday from IT. So in the next couple of weeks, I'm hoping we'll be able to roll that out. And when we do, look for that information in your email. And once that's finalized, I'll be bringing kind of the results of that back to this group to talk about identifying work priorities and what this group wants to do and how to structure their work for the next calendar year. So that's the first thing. We had talked a few months ago, over the last couple of months, we've talked and you all have heard from the sheriff about the jail population, and we've discussed creating a jail review process at different points. And so that work is still ongoing, creating kind of what that process actually looks like. And there were several of us who met a couple of weeks ago. We had representation from the judiciary, from pretrial services, sheriff and the jail staff, and the district attorney's office. And there's some logistics that we're still kind of working through about how that process can move forward in the most streamlined and efficient way. So as those discussions continue, we will keep y'all posted about how that comes together. But just want to make sure you all know that we are still having those discussions and trying to create a process that is not overly burdensome on reviews for all parties, and that can hopefully increase the releases for those in custody that are safe and appropriate for the community. And then the last update that I have, I'm not sure how long ago this potentially came up. I can't remember if Mike Brower in his role had talked about this, but the Justice Management Institute, which is a nonprofit technical assistance and consulting firm out of the Washington, D.C. area, they have supported a national network of criminal justice coordinating councils since 2010. There were 30 original counties that they have brought together in kind of a peer support network. So it's not like a learning initiative, it's not like a grant initiative or things like that. It's really it's a support network for people in my positions and the jurisdictions that support them to review, provide support around developing model practices to increase efficiency of criminal justice coordinating councils, addressing common challenges that jurisdictions have in criminal justice systems. And it's a very small, kind of tight-knit group of communities, and they're fairly diverse. They provide a lot of resources that are free to other jurisdictions that are not part of the network, but it's kind of a different level of support if you can become selected to become part of the network. They have not increased or expanded the size of the network since 2010 until now. So they, a week and a half ago, I believe, released the call for applications to expand the network beyond 30. The 30 original counties. So I've been kind of talking with Sarah. This was initially, I did not know they were kind of talking about this, but initially in part of my interview process, this would have been one of the things that I had said I wanted the CJCC to do, would be to try to get into this network. So we are I'm looking at the application, and I would like to apply on behalf of Douglas County. We're one of the few counties other than Johnson in the state of Kansas that actually has a CJCC. I know we already work closely with Johnson County. We have previously, my understanding from Mike is either under Mike or it might have been under Robert Benecki, but we have previously applied and have not been selected. So I'm hoping that maybe the tide will kind of shift now that they're looking at expanding. And I think it would be JMI does not have a close network of like counties that are close physically and already have kind of established partnerships to look at how model practices could be rolled out in more of a regional direction. I think that's one of the things that we could help support the idea of that. So I just want to share that with you all and hopefully we, there's not a lot of objection maybe to applying. It would give us a lot of addition of access to resources and a lot of extra support around not just how our CJCC functions, but support to other other disciplines and aspects of addressing some of the challenges that we may experience here. So that was all I had, Pam. I don't know if there are questions or other information that you or Sarah wanted me to share around those.
Thanks, Katie. Do you need something from the council to apply? No, okay.
No, it's very short. It's like it's one question. There's one question on this application. And it is what they can expect Douglas County to contribute to the fields. So I'm kind of culling through. I will probably be reaching out to several of y'all for feedback around that. Mike Brower and I have talked about this as well, since he is the representative on the network for Johnson County. And he and I both really feel like the partnership or the ability to create kind of the physical closeness, but also some of the political alignment and work towards, we share resources. We're sharing a lot between the two of us. And that is, we both feel like that might be a selling point for our application, because they don't have that across their jurisdictions are very, very sporadic and kind of spread out. So,
And I guess I just wanted to go back and talk a little bit about the jail review process, just so that the CJCC understands that, we are trying to work through what those processes and procedures and what will all be done look like. When we do, we will report back to this group so that they understand, if that wasn't clear, just that you all understand what those processes are and how that work is going to happen. I still envision that we may have some sort of jail review committee, but we're trying to operationalize that work and make it happen, make it be part of our everyday work. And then we'll bring it back to this group so that they understand.
Great. Suzanne, you have a question?
Just a quick one for Katie. Katie, did you say that there's only 2 organized CJCCs in Kansas, Johnson County and Douglas County?
yes.
Okay,
That's
so
what Mike has shared with me. And so I think there's lots of opportunity that brings for us, not just within this network. I mean, ideally, this being selected as one of the kind of formal participants in this network would help, could help position our 2 counties too, just within the state, to help support other jurisdictions who may want to create and implement coordinating councils. But as far as we know, there's just us and Johnson. I think other counties have discussed the possibility of pulling a group together, but.
Great, thanks for the update. Our last agenda item is the jail population update with Sheriff Armbruster.
Pretty quick today. This morning we were at 148 in county with another. I didn't get the exact number. I believe it's still 12 housed out of county. We spiked here over the last few weeks, upwards in the 150s and near 160 at one point, but we've come back down to earth a little bit. Changing of the weather usually signals a little bit of a turn in our population, but I do feel like, we're every week we're picking up a new inmate with very, very serious charges that will be staying with us for a great amount of time. You can just kind of watch the newspaper and see that we're having some very serious crimes occur here, which are creating just that, we may lose 3 people out back into their homes or back out onto the streets, but we're picking up one that's going to be with us for months, if not years. So it's still a bit of a dance, but right now we're maintaining. As we're still full, we are still housing people in places that were not designed to be housed, and we're making do with what we have. So thank you.
Thank you. Sheriff, I have a quick question. Are you still following COVID protocols at the jail?
So we are still following the quarantine and symptoms. We're not doing any more testing. Our staff has finally been able, only like 3 weeks ago, they finally stopped wearing masks full time. For those of us that work outside of the jail, you don't realize what a big deal that was for them to finally get to come to work without a mask on for 12 hours. But we, of course, are still monitoring and making sure. But we've stopped our because we were testing all inmates that, or all detainees that came into the facility. They were being quarantined. Now we're only doing it if they have, if we have concerns, or if they have symptoms, or if they have an exposure. We've stopped the testing of our unvaccinated or the employees who don't wish to disclose their vaccination status. We stopped doing that as well, and we stopped the masks for now.
Thank you. Do we have any other questions for the sheriff? Seeing none, this is the time for public comment. Zaina, do we have anyone out there that would like to ask questions?
No, not right. Nope, nobody at this time.
All right, do we have anything else for the good of the order today?
Katie, do we want to just go ahead and mention to the group that I think our plan is to cancel the December meeting? Just so people can manage their calendars more effectively. That means we've got one more meeting left this year.
Great, thank you for that. This meeting is adjourned. The next CJCC meeting is on November the 8th, Election Day. We'll see you all then. Thank you very much.
Thank you.